Today on Everyday Injustice, we have the head of the California Public Defenders Association, Kate Chatfield. Kate has done a number of things in the last several years. She had been chief of staff to Nancy Skinner and San Francisco DA Chesa Bodine, and probably one of the biggest marks she's left has been drafting SB 1437. So welcome to our show, Kate.
Thanks, David. Thanks for having me.
So, as the executive director of the California Public Defenders Association, what is it that you actually do?
Yeah, good question. Well, the California Public Defenders Association has been around since 1969, and it is a member organization. So our members are public defenders and indigent defenders. We have about 4,500 members currently, a little bit less, and then we have another couple of thousand that sort of are in our orbit, I would say. And these are not only attorneys, but attorneys, social workers, defense investigators, paralegals, allied defense professionals who work in indigent defense in California, whether in an institutional public defender's office or whether in private practice, whether on a contract panel. We can get into what that means if people don't know how the systems are set up. But so they work in indigent criminal defense. And it's important to note that when we say indigent criminal defense, this is not like a small class of defendants in the criminal legal system. 90% of people who are in the criminal legal system have a public defender. They are too poor to afford their own counsel. So we can get into that. That says a whole lot about our criminal legal system and who it targets. But those are our members, and that's what CPDA does. We lobby at the state capitol for criminal legal reform, along with many other, advocates, and we put on trainings for public defenders. We just, work together to keep public defense at the, I guess I would say, like at the, to elevate its place within the legal system. As it exists.
And we've gotten to see quite a bit this year on the state of public defense in California. The Wren Collective put out a big study on various aspects of it. We've done a couple of podcasts and some articles on that. We just did an interview with Ricardo Garcia, LA's public defender. We were talking about Prop 36 and how that's impacted the office. And then over the last 3 weeks, we were talking about this before we went on the air. I've been in San Francisco covering the unavailability hearings that are going on there because the public defenders are overburdened. And so a lot of the things that you've been talking about with conflict panels and caseloads have been discussed. And I've learned way more about the conflict panel in San Francisco than I ever thought I would. But it is very interesting
Yeah,
stuff. And I think a lot of people don't really understand that, public defenders carry the bulk of this, but not all of it.
correct, correct. Public defenders, what we, call like institutional offices, or like what you think of, the public defender offices do carry a lot. But yeah, I mean, even in one county, there can be multiple systems of public defense. So to take Los Angeles, for example, there's, you talk to Ricardo Garcia, he's the LA County Public Defender, but there's also another office. There's the alternative public defender. And then they also have the indigent defender conflict office. So, and this comes up, and your viewers or listeners may know this, but if there's a multi-defendant case, if more than one person is charged in a case, the one office can only represent one person. So if there are three co-defendants, one person would be represented, I'm just hypothetically, by the public defender's office. If the second person could be represented by the alternate defender's office, and the third person would be represented by somebody who's a private attorney on the conflict panel. Now, of course, that has all sorts of different, if there are witnesses in the case and they were previously represented by, let's say, the public defender's office, and the public defender can't represent any of the defendants in the case, and so then it would go to a conflict panel or other offices in the county.
Yeah, there are all sorts of little idiosyncrasies. And
Right.
then, the big issue in San Francisco right now is that the public defenders believe that they've taken on pretty much as they possibly can in terms of caseload. And there are guidances. They were saying, and you can correct me on this, but I think it was 1,700 hours a year is what the Bar Association says. And, some of the staff from the public defender's office said they're taking on like 3,400 hours a year. So obviously that is a big issue because, a lot of these are great attorneys, and I'm not trying to disparage, but if you're spending 3,400 hours a year, you may not be able to give them as good a defense as you possibly can.
Right, right, right. I mean, yeah, there, I think you're referring to sort of workload standards and how many hours you should, or it's acceptable that you put on the case depending on the seriousness of the case. So, and even I think sometimes, depending on the attorney, those can be even low, like the national standards. You can put in a lot of hours on, a little, as we used to say, or as we say, there's no such thing as a little case. It's you say, oh, it's just a misdemeanor. Well, you have a client in front of you with a misdemeanor, and this misdemeanor can have like really enormous consequences for somebody. There are fines and fees. This person could be, working person. There could be implications for that person's ability to maintain a license if they have, I mean, I'm talking about a driver's license or any kind of a work license or things like this. There could be immigration consequences to a conviction. There could be, just all sorts of negative outcomes that flow from a criminal conviction. So you really want to work to mitigate that for your client, from whether it's, a misdemeanor on up. So it really is, again, like if you believe, as public defenders do, in zealous advocacy for your clients, again, it's hard to say this is just a little case, or, this is a meaningless case. And
And I
it's
think
certainly
that
not meaningless to the person standing in front of you.
Oh yeah, for sure. And we see these collateral consequences all the time of convictions. And it's one of the things I train my interns to look for is that, even things like bail, the decision to hold somebody on bail versus releasing them on OR has huge collateral
100%.
consequences because it means they can't work or they may lose their housing or and one of the things we were talking about or they were talking about is that the nature of the clients has changed in the last 20 years. And so you see all these people that are either unhoused or housing insecure and they may be suffering from mental illness or they may be suffering from substance use disorder. And so it's rarely a straight criminal act anymore. The vast majority of people really need help rather than incarceration, but trying to get that takes a lot of time and a lot of work and a lot of advocacy on the behalf of public defenders.
Yeah, 100%. We often, think about, a client's criminal case is the tip of the iceberg. I mean, think about the glacier that's underneath the water, that all the things that led to the, let's say, the arrest. It's the housing insecurity, it's the job insecurity. It could be a lot of, trauma. It could be a lot of different things. And unfortunately, our system is set up in such a way that we just funnel people into the criminal system, into the criminal legal system, rather than, providing all that crime prevention that is social, social welfare, social services, and meeting their so many of their needs that would have avoided sort of the arrest in the first place, So yeah, that's a big, yeah, that's a big thing.
And going back to, the caseload issue and things like that, it seems to me, watching all this, that the real problem is that we're just not funding these kinds of things sufficiently. And so we don't have enough public defenders. We don't have enough social workers. The biggest mental health facilities in most counties is the county jail. Uh, we're supposedly doing all these things like Prop 36 to put people into treatment, but we're not getting them there.
Correct. And what are we funding? I mean, at a county level, we are funding police, law enforcement, sheriffs, and jails, and district attorneys. We have no problem finding the funds for that at the county level. What we seem to have problems with are finding funds for human needs, for housing, for healthcare, for all of those, for education, job training, substance use, treatment, so just healthcare in general. So all of those things, we seem to have a big problem with funding, but we have a system set up where we fund police and jails.
Yeah. So, I mean, from your perspective, how do we change that narrative?
Well, I think, how we, you know, as public defenders, like we're always trying. We're always trying to make the people that we serve human beings. I think in the public eye. I think that we have worked and we've been pretty successful in part with a lot of other people and organizations. It's something, getting away from referring to people as, as criminals, as defendants, as, they are like people are in technically in the legal system, but really trying to center people's humanity when we talk about them, because, these are the clients that we see, they are so the system I work so hard to dehumanize them, and so that somehow in the public imagination we forget that these are, people's sisters and mothers and brothers and fathers that are, the thing that connects them all is that they're poor, and our society really hasn't shown the inclination to address poverty in a systemic way such that it would keep people out of the criminal legal system.
Now, I want to shift gears here. So last week, there was an interesting story out of Oklahoma. One of the few times this year, good news for people that are opposed to the death penalty. They granted clemency on the eve of the execution of Tremaine Wood. And it's a really interesting case because it's a felony murder case.
Mhm.
And of course, felony murder is at the heart of 1437 and a lot of the work that you did. But this is kind of a classic case. And it's not just a classic case about felony murder, it's also a classic case about the luck of the draw in terms of who your defense attorney is. And so, like, the actual killer in this case was not Wood, but it was his brother. And his brother had better defense. And so he got a life sentence, and Wood got the death penalty, and he comes within hours of being executed. And it's only because of a 3-2 vote from the Pardon and Parole Board recommendation. And then the Republican governor of Oklahoma finally did one right and commuted it. So kind of, and I don't know how familiar you are with the case, even though it's been, pretty heavily covered in the media, but talk about felony murder and why it's so problematic.
Yeah, so 1437 was a bill in that the legislature passed in 2018. Governor Jerry Brown signed it into law. Senator Nancy Skinner was the author, and as you said, I was the lead drafter of that bill and an organizer of the coalition that came around to to pass that bill. And what SB 1437 did, among other things, was that it narrowed the circumstances by which somebody could be charged with murder for in a felony in which somebody died. So under felony murder, the sort of traditional or the old felony murder in California, that if, let's say, three people participated in a robbery and one person pulled out a gun and killed somebody, all three people can be charged with murder because the intention to commit the robbery, the intention to do that substitutes for the intention to commit the murder. So it's not like it doesn't, we don't care, that you didn't intend for anyone to be killed by agreeing to participate in the robbery. Somebody died, so therefore you can all be charged with murder. It's almost like a strict liability standard in that way. And so when we started the 1437 sort of organizing, we went, we had a survey that we sent in to, and 1437 did other things. It abolished a doctrine known as the natural and probable consequences doctrine, which is a common law doctrine of murder. And it's similar to felony murder in particular ways, though the underlying crime could actually be a misdemeanor with the natural and probable consequences doctrine. And then we abolished also a second degree felony murder that we had here in California. So without getting into the weeds too much on that, what we did is we had a survey that we made. We wanted to get a sense of how many people was this impacting, how many people were in prison in California for this doctrine. Now we couldn't, because when you go to prison, you get an abstract of judgment that's sent in with you into the prison, and it just says like murder one, that you're in for murder one and you're sentenced. It doesn't say what the district attorney's like theory of the murder. Is it felony murder? Is it something else? So so at any rate, we sent this survey out and we asked, people to fill that out. What are you in for? And we tried to write it so that it could get at was there a co-defendant? Did you, was there an intention to kill? Would you remember, what was the district attorney's theory of the case? Like, did you hear the terms felony murder and all these different kinds of questions? And then we did some, looking at appellate records to sort of, cross-check. And, but we got, we had family members send in this survey. We got them in through prison volunteers. Chaplains brought them in, and so people would fill this out and mail them back to us. We got well over 400 surveys back. And what we found is that the overwhelming number of people that were convicted of felony murder were young, definitely under the age of, for men, under the age of 25. 26, definitely in that. I think the average age was 22. We found that 72% of women that were convicted of felony murder were not the law says were not the actual killer. They were the accomplices. And we found that it was disproportionately applied to young Black men and Latino men.
Shocking.
Yes, yes. So it really tracks with our criminal legal system. So that was, that sort of felony murder. Now back to this. So, this case in Oklahoma, yes, I read about it in the media. It just tracks with, what we know, what we found out when we were doing all our work to get 1437 passed, that we would often say, it's not what you did. It's one of the many, injustices of the criminal legal system generally is not what you did, it's where you did it. So in California, like what county, did you do it in? Because that's a huge difference in the sentencing. There are some counties that, for the same act, you may get, the death penalty, whereas in another county, you would not be charged with a capital crime, versus, life without the possibility of parole or, just a quote normal, life sentence for murder. And it's definitely, the quality of lawyering is enormous, which is why is an enormous distinction, difference in outcomes that people experience. And and it's one of the reasons, one of our huge goals at the California Public Defenders Association is to increase funding for public defense. It is a very underfunded and incredibly important job, and with huge consequences for people. And, there is both a federal constitutional mandate under the Sixth Amendment. Everyone has the right to have an attorney in criminal court. And it's also a California state, right, a statutory right, that you have the right to appointment of counsel if you can't afford a lawyer. So, it's incredibly important. And we see that the consequences of having, bad lawyering. Now, it's not, of course, a one-to-one correlation that, if you're paid well, you're going to be a great lawyer, or, the reverse, that if you're paid poorly, you're going to be a terrible lawyer. I'm not trying to say that, but there is, somewhat of a correlation between, the quality of lawyering and how much a state or a county funds that public defender's office.
Yeah, and that's an important point. I've covered a number of these 1437 cases, and some of them, are kind of close calls as to whether or not, their level of involvement probably necessitated the charge. But then you get these crazy ones, right, where a couple guys, made pretty loose plans, and the guy was at home, and the other guy robbed a place, and it went south, and he ended up shooting and killing the guy. And it's like he's not even there. They made these loose plans, and yet he got convicted of murder. And and then I know several people that I believed were wrongly convicted, and but they were wrongly convicted as accomplices. And so one guy was convicted on natural and probable consequences. After the law passed, they overturned his conviction, came back, and then they had to prove that he was directly involved in the murder, and they couldn't do it, and so he was
Wow.
acquitted. So he went from having a life sentence to walking out after the trial.
Yeah.
Um,
Amazing.
and he was a young guy, and he spent 7 years in there. But it was very obvious, especially in the second trial. I actually got to see both trials, but in the second trial, they were able to show enough video to show that he couldn't have been there.
Wow.
And so, like, that just changed a guy's life.
Yeah.
And then there's another guy, he's been in for 20 years. He was supposed to have a hearing last week to have the murder conviction overturned, but there was some snafu, so they're coming back in December. So we'll see if this guy gets out. But he also had a life sentence and wasn't the shooter. It was a CHP officer that got killed, tragically, but it wasn't this guy who did it. And so,
Yeah.
the other guy has been on death row, but this guy had a life sentence, and he's
Mhm.
not young. Like he's
Yeah.
probably about 70 at this point. So,
Wow.
and he's
Yeah.
been in, like I said, for almost 20 years. I want
Yeah.
to, oh,
Yeah.
go ahead.
No, I was just going to say, I mean, we're talking about it, and maybe all of your listeners are in California, but I mean, one remarkable thing about 1437 was that it allowed for resentencing. I mean, if Tremaine in Oklahoma had been in California under that situation, it wouldn't be that he would be commuted to LWOP. He could be out of custody, and there was a big report. I'm not sure if you covered it already on recidivism rates for some of these resentencing, and
Yes.
recidivism rates for felony murder are incredibly low. I think there were like three people out of like 1,500 or more that had were charged with a serious or serious felony in the aftermath. So it's like it's not even, I'm not talking 3%, I'm talking like three people. I mean, it's just the recidivism rate is near zero. It's incredible. Yeah.
And that's not surprising. I think we did cover this, but it's not surprising if you understand kind of these dynamics. A lot of people, want to exempt a lot of these violent crimes, and yet for the violent crimes, especially murder, like the recidivism rate is extremely low. And
Right.
part of it is kind of the nature of the crime, but also how long they spend. And, by the time, you're in your 50s, 60s, 70s, you're probably not going to commit another crime anyway.
Right.
So, we're really sentencing people long after the point at which they're dangerous, even if you believe, like I do, that, we're sentencing far too many people anyway.
Right, right, right. No, that's definitely what that data shows is that, 15 years is the absolute ceiling, if you're concerned about public safety. So,
So the last thing I wanted to kind of talk about was Prop 36.
mm,
And it's an interesting topic because it's kind of the first wave of maybe a pushback against reform. I personally believe, and you probably agree with this, that a lot of the problems that happened around 2020, 2021 really were related more to the pandemic and the disruptions to massive society. We've seen crime rates have kind of gone back to where they were, and in some cases they're even lower than where they were 2019. So, Prop 36, in my view, really problematic. You know, Even if you believe, and I do believe that a lot of people need to get treatment, but we also know, and I know you and I have discussed this before, that forced treatment isn't the way to go.
yeah. I think I almost I don't want to take the Prop 36 proponents at face value. You know, they used language like treatment to in a very disingenuous way. It's not about treatment. It really is about incarcerating more people. It was also, heavily funded by the California Republican Party. I think the lawyer on it, if that drafted Prop 36, which was drafted terribly, is actually the lawyer for the, California Republican Party. So it was a get out the vote for, a lot of congressional races that were happening in California. And yes, they had a lot of money and they had this, you know, they were able to, I think they even put like a solving homelessness or addressing homelessness in the ballot title, which
Right.
it had nothing to do with homelessness. So they were able to capitalize on people's frustrations, maybe the voters' frustrations about the state's inability to address, our housing crisis and talk about it, as, oh, we can solve this with treatment for people, and then we can, somehow solve these issues that can never be solved in the criminal legal system. For, if you have any knowledge really of the criminal legal system, these solutions, just, putting someone in the criminal legal system just, tends to make things worse in their life, not better. So anyway, it's just it's almost like, yes, I could say it, it's bad, it's not working. Or I could say, it's working as intended, it's working as the proponents intended, which is increasing county jail populations, increasing the budgets for the sheriff, increasing the budgets for, law enforcement, because we're, funneling people into the criminal legal system who really, when really the needs are, housing and healthcare.
Yeah, and I think that's the key point is, we're putting our money in the wrong place.
Right.
And I completely agree with your take on, the disingenuousness of the campaign, of the narrative. Add to that, the fact that we now know crime was going down at the
Yeah.
time. The whole retail theft thing, as you well know, has always been overblown. It's amazing. They're complaining that their hands are tied behind their back, and yet, every single one of those retail theft cases were charged as felonies. So the existing laws gave them enough discretion to be able to charge them with felonies. Oh, shocking.
Yeah.
So what exactly are we gaining out of this, other than increased jail populations, which are going to cause us problems in the long run?
Yeah, I can't argue that we're gaining anything, and that, by this, there were other ways to deal with retail theft that the legislature was doing, and I'm talking like even outside of the criminal legal system, like forcing online marketplaces to, assess, goods that might be being stolen. I mean, that was a huge funnel for stolen goods, was, Facebook Marketplace and other markets. And if you shut that down and make them report on things and verify their, sellers, then, surprise, surprise, suddenly the benefits, I guess, of any theft is greatly reduced if you don't have a market to sell the goods. So, um,
Yeah, and that was one of the bills that Nancy Skinner sponsored last year.
right, right. So, I mean, there are other ways to deal with it, but again, so I'm not going to take the proponents at face value, because it's not a solution to the problems that voters want addressed, which is housing and healthcare. So, but unfortunately, they were able to, use enough of the lingo of treatment, which voters do want. People do want people to get treatment. And,
Well, it makes sense. I mean,
yeah,
if somebody is sick, which is what mental illness is, which is what substance use disorder is, they need treatment. Putting
right,
somebody in a cage doesn't treat them.
right, right, right. Yeah, yeah.
All right. Well, we're out of time. Thank you for joining us, Kate.
Oh,
As
absolutely.
always, good talking to you.
Yeah, very good talking to you as well. And yeah, thanks for doing this. Thanks for all the questions. It's good.
This has been Everyday Injustice. I'm your host, David Greenwald. Join us again next week for more tales from the injustice system.